All right, let's dive right into this explainer and decode the ultimate workplace rulebook that impacts you every single time you clock in or sign a paycheck. Whether you're turning a wrench on a construction site or typing away in a cubicle, the Occupational Safety and Health Administration, better known to all of us as OSHA, has fundamentally shaped your environment. Today, we're looking directly at the framework of the OSH Act. We're going to unpack exactly how the rules are made, what happens when a rule doesn't quite fit a brand new hazard, and precisely what rights both you and your employer have under this massive system. Here's our roadmap for today. First, navigating OSHA standards. Second, the General Duty Clause. Third, rights and responsibilities. And finally, OSHA's safety services. Okay, let's start with Section 1, Navigating OSHA Standards. So the rules are actually split right down the middle into two distinct types. On one side, you have vertical standards. These are highly specific, laser-focused on a particular industry. Think about regulations for fall protection or scaffolds. I mean, if you don't work in an industry that uses scaffolding, those rules simply don't apply to your day-to-day. But on the flip side, you have horizontal standards. These are the universal rules, and they stretch across the board, affecting almost every workplace out there. We're talking about hazard communication, bloodborne pathogens, and rules for powered industrial trucks like your everyday forklifts. These foundational rules are meant to protect workers universally, no matter what industry they happen to be in.
But you know, before any of these standards, vertical or horizontal, can actually protect anyone out on the floor, they have to be officially created. They have to survive the whole bureaucratic journey of the standard-setting process. And let me tell you, it doesn't happen overnight.
There's a four-step life cycle to this. First, OSHA initiates the development. They spot a need and start the ball rolling. Second, they publish their intentions in the Federal Register. That's officially called a Notice of Proposed Rulemaking. Third, it doesn't just pass quietly in the dark. The proposed standards go through a really rigorous public comment period and hearings, which allows for actual feedback. Finally, Step 4, OSHA publishes the full, final text of the standard, along with the date it becomes effective, right back in the Federal Register. So it's a very structured, transparent process from start to finish.
But all of this raises a massive, kind of suspenseful question. The modern workplace changes so incredibly fast. New technologies and new chemicals appear literally all the time. So what happens to you when a hazard pops up that OSHA just hasn't specifically written a rule for yet? What if it hasn't gone through that whole four-step process?
That brings us right to Section 2, the General Duty Clause.
This is where the ultimate safety net comes into play. The crucial point is embedded right here in the OSHA Act's General Duty Clause. Basically, if OSHA doesn't have a specific standard to address a hazard, employers are absolutely still responsible. The text explicitly states that each employer shall furnish a place of employment free from recognized hazards that are causing or are likely to cause death or serious physical harm. This is a huge deal. It means OSHA can cite an employer even if there's no specific rule on the books that was violated. Sure, nobody likes getting a citation, but it definitely beats the alternative of working in an unsafe environment.
Now, for OSHA to actually issue a citation using this General Duty Clause, four specific elements have to dynamically align. 1, the workplace wasn't kept free of a hazard. 2, that hazard was actively recognized. 3, it was likely to cause death or serious harm. And 4, this is key, there had to be a feasible and useful method for correcting it. If all four of those elements are present, you've got a violation.
Let's move on to Section 3, Rights and Responsibilities.
When you look at how this is structured, there's a really fascinating symmetry here. It balances the scales. Both employers and employees get a voice, and both share the right to comment on standards while they're being formulated. If an employer applies for a temporary or permanent variance from a rule, the employees have the absolute right to be informed about it. And when it comes down to an inspection, employers have the right to be present, but employees also get the right to have a representative there during that exact same inspection.
Drilling down specifically into the employee side of things, this framework guarantees some incredibly vital protections. As an employee, you have the fundamental right to a safe work environment. Crucially, you have the right to complain to OSHA without any fear of punishment or retaliation from your boss. You're also empowered with access to information. You can review injury and illness summaries, your own personal medical records, and you can review any OSHA citations your employer receives. You even have the right to directly observe the monitoring of toxic substances in your workplace. But shifting gears impartially to the employers, the OSHA Act grants them distinct structural rights too, ensuring fairness. Employers have the right to formally file a notice of contest if they disagree with a citation. They're guaranteed the confidentiality of their trade secrets, meaning safety inspections won't lead to a loss of proprietary business info. They can also get compliance assistance directly from OSHA. And, like we mentioned earlier, they have the right to apply for a variance if they have an alternative, equally effective way of keeping their workers safe.
And that brings us to our final part, Section 4, OSHA Safety Services.
It's so vital to understand that OSHA isn't just a punisher, they're a partner. They provide proactive services designed to promote safety and help build a culture of health from the ground up, rather than just waiting around to hand out fines when something eventually goes wrong.
First up is OSHA Consultation. This is an incredible resource. It exists specifically to help employers who actively want assistance in establishing and maintaining a safe workplace. It literally allows employers to invite experts in to identify issues before they ever become a hazard or a citation. Next, we have the Voluntary Protection Programs, or VPP. This is a really cool part of OSHA's effort. It's designed to champion companies that enthusiastically push their worker protection way beyond just the bare minimums required by the standards. It's for organizations that want to be the absolute gold standard in workplace safety. Finally, there is the OSHA Training Institute, often called OTI. This serves as the educational powerhouse of the whole organization. It provides both basic and advanced training to make sure that the knowledge required to keep a workplace safe is continually being taught, updated, and passed right on to safety professionals.
As we wrap up this explainer today, I really want to leave you with a provocative thought. We've seen how vertical and horizontal standards are made, we've unpacked the vital safety net of the General Duty Clause, and we've explored the balanced rights and supportive services OSHA provides. So knowing this comprehensive framework exists out there, how well do you truly understand your own rights and responsibilities in your specific workplace? The next time you walk through your employer's doors, take a look around. Understanding the rules is the very first step in making sure they actually work for you. Keep learning and stay safe.